Did you know that the Social Security Administration can actually take you to court and sue you if they believe you were overpaid on SSI or SSDI benefits? That's right. Not just taking money out of your check, but filing a lawsuit in civil court backed by the Department of Justice. Most people think overpayments just mean a letter in the mail or a few dollars missing from their check, but this new policy reveals a much bigger picture. The real question is, would you survive if the SSA decided to sue you? In today's video, we're going to uncover everything the SSA just updated in its internal policy manual. When they can sue, when they can't, how much debt triggers lawsuits, how long they have to chase you, and the shocking 3 levels of penalties that range from losing benefits all the way to prison time. This is powerful information that most attorneys don't even share publicly, but you need to know it because it could impact your benefits, your finances, and even your future. Before we dive in, please take a second to like this video and subscribe to Social Security Post, your trusted source for breaking Social Security news. Just days ago, the Social Security Administration updated its policy manual, known as POMS, with a section labeled SI0220TN135. This is the book of rules that SSA attorneys, managers, and executives quietly use behind the scenes. On the surface, it looks like an ordinary technical document, but inside, it completely reshapes how SSI overpayments are pursued. It went into effect on August 20th, 2025, and is already live across SSA offices nationwide. This update specifically focuses on Supplemental Security Income, or SSI. But here's the kicker. While the rules are written for SSI, the style and approach mirror what happens in SSDI and even retirement benefits. So even if you're thinking, this doesn't apply to me, the truth is, it just might. What we're looking at is not only a rule book for technicians, but a window into how the government may decide whether to forgive your debt or drag you into court. During the Biden era, overpayment recovery was loose. Many beneficiaries breathed a sigh of relief when the administration signaled it wouldn't aggressively collect certain debts, especially during the pandemic. That meant countless seniors and disabled Americans didn't have to worry about paying back thousands of dollars in mistaken payments. For many, it felt like a lifeline. But fast forward to today, and the tide has turned. Under Trump's leadership, there is a strong push to tighten the ship and demand accountability. With the national debt climbing past $37 trillion, the administration argues that every penny counts, even from overpayments. Supporters say it's about protecting the system from collapse, while critics argue it punishes the most vulnerable. So here's the question. Do you prefer the forgiving Biden method, or the strict Trump approach that insists the government must balance its books, even at the expense of beneficiaries? Here's where it gets serious. According to the new policy, the SSA can refer your case to the DOJ Department of Justice for civil lawsuit if all other efforts fail. That means if you ignore refund requests, decline repayment plans, or simply can't pay, they have the authority to escalate. But not just anyone qualifies for this level of enforcement. The DOJ will only take the case if the debt is significant enough, generally $3,000 or more, and if the SSA has strong evidence that the debt is real. They must prove their case with documented evidence, not just speculation. If fraud is involved, the stakes go even higher, with investigators collecting proof before sending it to DOJ prosecutors. So imagine this. You think an overpayment letter is just a piece of paper, but behind the scenes, the gears of government are turning, and you could be the next defendant in court. Now, not every overpayment turns into a lawsuit. There are guardrails. For example, debts under $3,000 typically won't trigger a DOJ referral, unless fraud or a federal employee is involved. If a person dies with no estate to collect from, the SSA generally walks away. Bankruptcy filings can also shield individuals from collection during the court process. But here's where curiosity kicks in. What about small debts, like $150 or $200? The SSA usually doesn't bother with those, but under the new rules, if you're a federal employee, even that small amount could lead to a lawsuit. Think about how strict that is. The very people who worked for the government may face the harshest consequences for the smallest mistakes. Debt size is at the heart of the new rules. For ordinary beneficiaries, $3,000 is the line in the sand. Owe less than that, and you're probably safe. Owe more, and your case could be handed to DOJ lawyers. For estates left behind after death, the threshold rises to $5,000. For payees who fail to transfer conserved funds, $3,000 is enough to spark legal action. But federal employees face an even harsher standard. If they owe as little as $200, they're fair game for civil lawsuits. Why? Because the SSA argues they should have known better. That means a former postal worker, veteran, or civil service retiree could find themselves in court over a debt smaller than a household utility bill. That's the kind of detail buried in this policy update that most people would never see coming. You might be wondering, how long does SSA or DOJ have to come after you? The answer is 6 years from the date the debt becomes delinquent. But don't relax just yet. That clock resets if you make even a small partial payment or put in writing that you acknowledge the debt. One letter, one small payment, and suddenly you've given them 6 more years to pursue you. And it doesn't stop there. The statute can pause entirely in certain cases, like if you move outside the U.S., if you're declared mentally incompetent, or even if the country enters a declared war. The result? Some debts can linger like a shadow for decades, waiting to be revived the moment conditions change. Most people think 6 years means the government gives up. In reality, the rules give them more than one way to keep the clock ticking. The SSA's system of penalties can be broken into 3 escalating levels. And yes, they can feel like whoopings. First comes administrative action. This is the mildest form, where they withhold benefits, reduce checks, or deny future payments until the overpayment is repaid. For many, that alone is devastating. But it doesn't stop there. Civil penalties are next, where DOJ sues in court to force repayment. And finally, the most severe, criminal penalties. These are rare but apply in fraud cases. Here, beneficiaries face not just repayment, but fines or even prison time. It's a 3-tier ladder of enforcement that turns what many see as a clerical mistake into a situation that could ruin someone's financial life or freedom. One of the most surprising elements of this policy is how the SSA decides if you can repay. They look at whether your income exceeds your necessary living expenses by just $250 a month. If they determine that extra cushion exists, they can argue you're able to repay. Over 5 years, 60 months, even small surpluses add up, and SSA will use that math to justify a lawsuit. It doesn't stop at income. Assets and resources are fair game too. Have a small savings account, a second vehicle? Anything they believe can be liquidated might tip the balance. And again, federal employees are judged more strictly than ordinary beneficiaries. What seems like a tiny margin of disposable income can be the basis for being dragged into civil court. Another layer is cost. Generally, the SSA won't sue if the legal costs outweigh the debt itself. But here's the twist. They make exceptions for federal employees and fraud. That means even if it costs more to sue you than the debt is worth, they'll do it anyway if they want to send a message. Think about it. Imagine being hauled into court for just $200 because you once worked for the government. That's not a hypothetical. It's written into the policy. To many, it feels less like financial efficiency and more like an intimidation tactic designed to remind beneficiaries that SSA has the full power of the Treasury and DOJ behind it. Here's how it unfolds. First, SSA documents your ability to repay, calling you, asking for financial details, and pressing you for a settlement. Next, they send a 30-day notice warning that your case will be sent to DOJ unless you respond. If you stay silent, they prepare internal reports, forward your case, and wait for DOJ's decision. This means by the time you see a lawsuit, the SSA has already given you multiple chances to cooperate. But let's be honest, for someone living on $943 a month SSI, even $50 payments can feel impossible. The problem isn't lack of warning, it's that repayment plans can still crush already vulnerable households. If your case reaches the lawsuit stage, the rules change dramatically. Before you receive lawsuit notice, SSA might still accept partial payments to stop the process. But once you've been served by the U.S. Attorney's Office, only full repayment will do. No more negotiating small amounts. At that point, it's all or nothing. And here's another twist. If you manage to regain SSI eligibility, SSA can resume collections by withholding from your new checks. But if you don't, you're left dealing with the DOJ directly. That means lawyers, court dates, and potentially garnishments or liens. It's not just about a missing benefit check anymore. It's the weight of the federal legal system on your shoulders. Bankruptcy remains one of the few shields beneficiaries can raise. When you file, an automatic stay goes into effect, a legal bubble where creditors, including SSA, must stop collections. If the debt is eventually discharged, that overpayment vanishes legally. But bankruptcy is not a magic wand. It damages credit. It can impact housing and loan opportunities, and not all debts are guaranteed to be wiped away. Still, for those facing lawsuits, bankruptcy can be a last line of defense. It's a reminder that even against the Treasury, there are legal tools beneficiaries can turn to, though the cost is heavy. So here's the bottom line. The SSA's new policy makes it crystal clear. If you owe more than a certain amount in overpayments, your case could end up in court. Under Biden, many debts were forgiven or ignored. Under Trump, accountability is the rule, even if it means suing the poor, disabled, or elderly. For some, it feels like justice. For others, it feels like cruelty. What do you think? Should the government be able to sue seniors, disabled individuals, and low-income Americans for debts that often come from SSA's own mistakes? Or should these overpayments be forgiven in the name of fairness? Drop your thoughts in the comments. I want to hear your opinion. And before you go, please like this video and subscribe to Social Security Post so you don't miss updates like this. Every change in SSA policy can have a direct impact on your benefits, and we're here to make sure you stay informed.